Hello again. Today we are going to speak about equity. The term equity in its company law context and the term equity in the financial sense or in the company law context really has a meaning which ties into the monetary value of something. Either the monetary value of property or business, the ownership interests shareholders have in a company, or just referring generally to the common stock or common shares of a corporation, ordinary shares for a corporation. That is in British English. But in this context, the term equity has a little bit different meaning, and this is the common law concept of equity. The principle of equity, which means fairness, the carrying out of justice according to fair principles. If you go back in England, there used to be courts of law and courts of equity. Courts of law were where you went if you wanted to get money, damages, and courts of equity were where you went if you wanted to get something else. If someone had stolen your cow and you wanted to get the cow back. Even though the courts have kind of merged into one, the distinction still exists today in the sense that equitable relief means any sort of relief other than damages, which is non-monetary, i.e. not money. The most common equitable relief is injunctions when talking about court orders to do or not to do something. But there are other examples as well. Specific performance, which is asking a court to require the opposing party to finish the contract, or rescission, which is asking a court to put an end to a contract, or restitution, which is asking a court to give not only on the contract, but to give back any unjust enrichment that one side has obtained from the other. Thank you. Hello, back again. Today we are going to speak about green shoe option. The technical term is an over-allotment option, which you will see sometimes it's referred to in prospectuses or in contracts or in underwriting agreements with the underwriter of a particular issue of shares. The green shoe option, when a company is publicly issuing shares for the first time in an initial public offering or otherwise, they generally enlist the help of an underwriter, and an underwriter is either a bank or a financial institution or an investment house who assists in the issuance, really underwrites the new issuance of shares in an IPO or otherwise, and they really work with the issuer of the shares to determine the price, the number of shares which are going to be issued, and the process and which investors will be targeted. The green shoe option is an option on behalf of the underwriter, or an option for the underwriter to issue more shares if necessary, that is, if demand exceeds what was initially anticipated by the issuer, the underwriter, or both. This enables the underwriter to generally issue up to 15% more shares than originally anticipated or originally scheduled, and its means of not only dealing with increased demand, but also a means of stabilizing the price of shares after the shares are listed. Thank you. Hi there. We are going to speak about the Latin phrase pro bono publico. The Latin phrase pro bono publico is usually shortened to just pro bono, and it means for the public good. In the law context, it's offering legal services to someone else for free without receiving compensation, and there is a number of reasons why you'd want to do this. Just for the public good and your own good and for the client's good, of course, but also many bar associations and law associations around the world now encourage pro bono service by either offering incentives to lawyers or in some cases even requiring a certain amount of hours to be devoted to pro bono work. Pro bono is usually used as an adjective. You take a case on a pro bono basis, provide a pro bono service, and you hire pro bono counsel. You may want to hire pro bono counsel, for example, in a dispute with a bank who keeps sending threatening letters to your home, hypothetically. License. There are two different spellings of license. License and license. Now, this is important when you are talking about the noun license, which is the actual document that gives you the permission to do something or to own something, and it's important in the context of the difference between UK and US usage. In England, the noun, the document granting a license, is spelled L-I-C-E-N-C-E. In the US, it is spelled L-I-C-E-N-S-E. Now, when it comes to the verb, it gets a little bit easier. The verb to license, which is the actual granting of or conveying of, the giving of the license or the permission to do something or own something, then in both instances, in the United Kingdom and the United States, the spelling is the same, L-I-C-E-N-S-E. So in the US, it's quite simple. License is always spelled L-I-C-E-N-S-E. In the United Kingdom, the spelling of license is different. If you are talking about the noun, the actual document, the license itself, then it's license. Be careful with the term debt, which is money owed. And this is not a spelling problem, but a pronunciation problem. So debt is spelled D-E-B-T. Whether you are in the United Kingdom or the United States, it is pronounced debt.